All rise. We would away. Please be seated. We have Sawa.
Yes, Mr. Edwards.
Yes. Your Honours, I was talking a little earlier about criminalisation. I'm not going to take Your Honours through it, but I'd invite Your Honours to read paragraph 40 of filing 561 together with the annex to filing 496, which was the registrar's report, paragraph 7 and 8 thereof, and specifically paragraph 8, in which I think these are confidential, so I'm not going to read anything from them. But the sentence starting with the word therefore.
But I do think, Mr. Edwards, I think I better make it clear to you so that you can deal with my... I think the objection by Mr. Nichols is correct. There's no evidence at all that this had any effect on your client's mind.
I was just I don't have anything more to say about that. I was just clarifying what the parties' positions were, and what Your Honour's finding was about continuing criminalisation. But if Your Honour finds that that's not going to move the needle, as it were, then I can move on.
Unless you can persuade me otherwise, I think the objection made by the prosecution that for the purposes of sentence, we have to look at what was in your... and allowing credit for his surrender, we have to look at what was in your client's mind. And there's no evidence at all that this had any effect on his decision or not to surrender.
Very well. I'm going to move on.
Yes, all right.
Having dealt with the issue of voluntary surrender, at point B, page 44 of the prosecution submissions, we deal with the question of the expression of remorse. That's covered at point J of the defence's submissions at paragraphs 91 to 100, and that will be dealt with by Mr. Lauchi very shortly. What I'm going to move on to, and I'm taking these in order in the prosecution submissions, that's why there's a bit of jumping around, I'm afraid, but we thought that was probably the safest way of doing it. Age, family situation, and lack of previous convictions. So this is at point C, at page 45 of the prosecution submissions. Now we cover these points at C, D, and H. I rely on those submissions, but I'm just going to expand on one or two points now. The prosecution, and I think the victims as well, say that family circumstances such as those of Mr. Abd-Al-Rahman are common to many convicted persons, unexceptional, and therefore undeserving of mitigation. Well, it's nevertheless something that you have to take into account because the statute says so. The prosecution rely in their submission that family circumstances and age and so on can just be swept away and ignored. They rely on the Yekatom and Gaisona sentencing observations, Bemba sentencing judgment. But we say these are inapposite to Mr. Abd-Al-Rahman's situation for this reason. Specifically relating to the loss of family members. Now, in Bemba, I think the issue that was pleaded on his behalf was that whilst in detention he lost both his parents and was unable to assist in burying them or visiting their grave. Mr. Abd-Al-Rahman hasn't lost a parent. He's lost a child. He's lost 2 children. Your Honours know this. He lost 2 sons. He had to mourn them alone in his cell, thousands of miles from his grieving family, unable to perform funeral rites for his children, to bury them, or to visit their graves, unable to be present with his family to comfort them or for them to comfort him. The Yekatom and Gaisona case law, such as it is, and Bemba, is not binding jurisprudence on Your Honours. This was the position taken by other trial chambers. Now, we're not suggesting that Mr. Abd-Al-Rahman's heartbreak at losing 2 sons in the course of his incarceration should in and of itself result in you reducing his sentence by very many years, but it's something that you can and something that you should take into consideration when determining the overall sentence. If you were to take the approach taken by the chambers in Gaisona and in Yekatom and Gaisona and in Bemba, that in essence that doesn't matter, would, in our respectful submission, be rather heartless. As far as his family situation is concerned, and we've addressed this in our submissions, but I'm going to reiterate 1 or 2 points. He has done his best to continue to support his family, and the ways in which he has continued to support his family demonstrate the authenticity of his family ties. They've been consistent, provoked by a genuine commitment and a genuine desire to support and provide for his impoverished dependents. He sends them the little money he's able to earn instead of spending it on himself to make the conditions of his detention here that little more bearable. This is not necessarily common to all detainees, and you can't find that it is common to all detainees.
Sorry, Mr. Edwards, but as a matter of interest on this question of support for family, I did remember that there was evidence that he owned more than one house in Rahat al-Badi, or property, had quite a lot of, which I don't think is part of the present conflict, although I may be wrong, quite a lot of cattle, sheep and whatever, plus houses in Garcilla and elsewhere. So are you saying that your instructions are none of that's available to his family?
Yes, well, our instructions are that if that was the case years ago, it is certainly not the case now. In a moment, I will refer you to a certain medical report, but I'm not going to be able to refer you to it in open session, I'm afraid. But there is a paragraph in that report that deals with this precise point. I'll put it on the record now so that we don't lose it. Just bear with me for a second. Now, I may be rather optimistic. I can't. No, I think I was too optimistic. I'll find it. I'll find it a bit later, but it's in that report. Paragraph 38 of that report. And while I'm on the topic, Your Honours will be aware that apart from a single family visit that took place at a time before the war broke out again. There's been no physical contact with his family at all since his arrival in the Netherlands. Video calls, which is better than nothing, but that's all. We set out in our paragraph 52 our submission that the trial chamber can and should take into account the impact of Mr. Abd-Al-Rahman's detention on the rights of his children, particularly his minor children. And there are 5 minor children, aged between 12 and I think 16, maybe 17. A substantial sentence of imprisonment seen from the perspective of those children punishes not only the father, but the children, the innocent children, also. The longer the sentence of imprisonment, the graver the impact. We deal with this in our submissions. I really don't need to repeat the matter, but we ask you to accept that that is a relevant factor to take into consideration in the determination of the overall sentence. As far as Mr. Abd-Al-Rahman's age, 76 now, by a significant margin the oldest convicted person to be sentenced at this court. For the avoidance of doubt, because it was raised by the prosecution, we're not suggesting that his age in 2003 or 2004 is of any relevance. It's not. It's his age now which is of relevance. He's a man who, if not in the winter months of his life, then certainly in the late autumn. Any sentence of imprisonment of any significant length is likely to amount in concrete terms to a sentence that will see him spending the rest of his life in prison, subject to everything that Mr. Lauchi will address you on in a moment. And that sort of a sentence in which the convicted person has, in essence, no hope of release before his death is particularly onerous. It is particularly harsh. It is far harsher for a convicted person of more advanced years than for a younger person. And where a convicted person is deprived of any hope of release, any hope of ever seeing his family again in normal circumstances, any hope of returning to one's homeland, any hope of any sense of normalcy, imprisonment becomes unbearable. This point of a lack of hope for convicted persons who are sentenced to what in the UK is described as a whole life term was, and Your Honour may be familiar with the case, it was dealt with at the European Court of Human Rights in the case of Winter and others versus the United Kingdom, 9th of July 2013. Grand Chamber, application numbers 66069 of 09, 130 of 10, and 3896 of 10. And Your Honours, we can send you the authority, but at paragraph 119 of that ECHR judgment, the Grand Chamber says this: the court considers that in the context of a life sentence, Article 3 of the ECHR must be interpreted as requiring reducibility of the sentence, in the sense of a review which allows the domestic authorities to consider whether any changes in the life prisoner are so significant, and such progress towards rehabilitation has been made in the course of the sentence, so as to mean that continued detention can no longer be justified on legitimate penological grounds. The argument that was put forward in Winter and others was a whole life tariff with essentially no prospect of parole amounted to a breach of Article 3. I raise that to set out some context to what the consequences of life imprisonment might be. Now, at this court, Article 110 of the Rome Statute sets out the test for, or rather the conditions for a convicted person seeking early release. Forgive me. It's of the statute, yes. Review by the court concerning reduction of sentence. In Article 110.2 states that the court alone has the right to decide any reduction of sentence. Article 110.3, when the person has served 2/3 of the sentence, or 25 years in the case of life imprisonment, the court shall review the sentence to determine whether it should be reduced. That tends to suggest, Your Honour, that if the court were to follow the recommendation of the prosecution and pass a sentence of life imprisonment, Mr. Abd-Al-Rahman would have no possibility of seeking a reduction of sentence until the passage of 25 years. He'll be 101 years old. So that's what I mean when I say, well, certainly a sentence of life imprisonment would deprive him of any hope of release, and any significant sentence at all would equally, in reality, deprive him of any hope of release. As Mr. Abd-Al-Rahman gets older, his life in prison, you can accept, I submit, will become more, not less onerous. Old age will increasingly become a vulnerability, and this is touched upon in paragraph 63 of the report that I'll return to a little bit later. Without identifying the author, paragraph 63 is not redacted, and for the purposes of this submission, I'm going to read it in full. Paragraph 63 is subtitled Age and Prison Environment. Older individuals in prison typically have higher health and social care needs, and prison settings are often not well adapted for aging. Open brackets, mobility, continence, nighttime support, close brackets. Extended detention tends to accelerate deconditioning and dependency. A lengthy custodial sentence is likely to intensify these pressures. I would submit that this is a matter of common sense. One doesn't need to be an expert to understand the truth of those observations. But in sum, we say this: deprivations associated with incarceration will become harder to cope with, are likely to accelerate the aging process. And really, he faces a future of being caught up in his remaining years in a vicious cycle of finding it, as he ages, finding it increasingly hard to cope in prison, which in turn exacerbates his frailties, which in turn accelerates the aging process, which in turn makes it even harder for him to cope, and so on. A spiral of greater and greater decline. Paragraph 65 of the expert's report deals with, in general terms, the mental health of older prisoners. That imprisonment later in life carries the risk of demoralization, low mood, sleep disturbance, reduced motivation, especially during lengthy sentences. The impact may become significant over the long term as isolation continues. Bereavements remain only partly processed. Language barriers hinder effective communication. Your Honours will know that in some countries, elderly prisoners are imprisoned in specialised detention facilities set up to confront the very particular challenges of accommodating the elderly. the downward spiral that I alluded to a moment ago in Mr. Abd-Al-Rahman's case might be mitigated if he were transferred to a country of enforcement that makes specific provision for elderly prisoners. But if not, and if Mr. Abd-Al-Rahman is obliged to spend his to serve out his sentence in the general population, this will likely contribute to making his sentence all the more onerous. So we say that the prosecution submissions that his age is not a mitigating factor. We say that's wrong. It is a factor to be taken into account in determining the sort of sentence and the length of sentence that your honours pass. At point D, I'm moving on now to what the prosecution say about...
Before you do, can we go back to this question of his houses, I'm afraid? You said to me a moment ago, and this is at page 46, line 18, when I asked you about the houses that we heard about in Rahad and Qasila and elsewhere, and indeed Niyara, that he no longer has those houses, but according to the report you just referred to, paragraph 16, where he deals with his family, where he says had 11 children, 5 you say are still minor. He says at the end, the report says, and this appears to be a direct quote, some members of my family are staying in my house in Nyala and some are in my town. And that, of course, goes also to the point that Mr. Lauche was beginning to develop yesterday and proposes to go back to, I gather, about the question of reparations.
Yes, thank you, Your Honour. I was referring, certainly in paragraph, there may be a house in Nyala and maybe one in Riyadh Bildi, but the nature of the paragraph 38 of the report says what kind of a house the house in Riyadh Bildi is. A straw house.
But yes, it doesn't explain what the others are.
Well, perhaps that's something I can take instructions on.
Certainly. You can do that over the break.
Thank you.
Yes, you were moving on to...
Yes, point D of the prosecution submissions. This is at paragraphs 154 and 55. We deal with that at G of our submissions, paragraphs 87 and 88, relating to behaviour in the courtroom and behaviour in detention. And the prosecution say, doesn't matter, completely irrelevant. Detainees, defendants should behave. Unlike the situation that I addressed you on a moment ago relating to jurisprudence of this court relating to voluntary surrender, it's right to say that the appeals chamber has weighed in on the question of good behaviour as being no mitigation unless exceptional. And with great respect to the appeals chamber, we say that they've got that wrong as a matter of principle. And we would invite your honours to not follow that appeals chamber jurisprudence. The appeals chamber says no, only exceptionally good behaviour in court or in detention could make a difference, without defining what exceptionally good behaviour in detention or in the courtroom would look like. But Your Honours, the report from even if the appeals chamber is right in saying that only this vague concept of exceptionally good should be taken into account, we would submit that the report from the detention centre is enough. It provides significant information of Mr. Abd-Al-Rahman as being a model detainee. He's not just fine, he's not just, he behaves himself, he's not particularly troublesome. A model prisoner. The report says he is always friendly, respectful, pleasant, and polite. Not just sometimes, not even most of the time. He is always friendly, respectful, pleasant, and polite. If that isn't exceptional, Your Honour, I don't know what is. We all have bad days. I expect that there are few people in this courtroom who could be described as always friendly, respectful, pleasant, and polite. But Mr. Abd-Al-Rahman is. And we say that as a matter of principle, such model behaviour should be taken into account in mitigation. Why? As a matter of principle, good behaviour in detention plays an important role in fostering the orderly administration of detention centres. Respectful relations between detainees and with detention staff creates a harmonious living and working environment. Willingness to contribute to that harmonious living and working environment provides strong evidence of a willingness to rehabilitate. And as a matter of principle, we say, that should be encouraged. There is nothing in principle that would suggest that that isn't right. If it is taken for granted in the way the appeals chamber in Taganda suggests is the right way forward, there's nothing to deter detainees from acting up, from being violent, from being disruptive, from being disrespectful. If there was evidence of that sort of violence and disruptive behaviour and disrespectful behaviour, of course there would be nothing to plead in mitigation. It wouldn't amount to an aggravating feature, but there would be nothing to plead in mitigation. But when the good behaviour, not just exceptional behaviour, but when good behaviour benefits everyone, that must be acknowledged. And as for behaviour in court, it should be highlighted that Mr. Abd-Al-Rahman has never engaged in any conduct that's been disruptive. He has never engaged in conduct that was intended to delay proceedings. He has always been anxious for the case to proceed as expeditiously as possible. He has never wanted to stand in the way of the case moving forward. On those occasions when he's been physically unwell, or on the sad occasions when he was grieving, he never suggested that that should hold up the work of the court. If he ever preferred to remain in his cell for whatever reason, he always sent a waiver, didn't he? Rather than exercise his right to be present in court, and thereby allowed the work of the court to continue, unmolested. And moving on now to the cooperation between the team and the prosecution, Your Honour, on more than one occasion has mentioned that there's been good cooperation. Dare I say, exceptionally good cooperation between the defence and the prosecution over the course of this trial, well, almost the entire course. But that has been made possible in no small part because of Mr. Abd-Al-Rahman's positive attitude to the defence's relationship with the prosecution. What do I mean by that? He could legitimately have given firm instructions from the outset not to engage with the prosecution, not to reach agreement, to, if I can put it this way, throw sickies on a regular basis and say, no, but I'm not going to waive my right to be present. He could have done that. He could have pursued what the French would call a défense de rupture, a sort of a defense strategy by which focus is on a denial of the legitimacy of the institution, engaging on total non-cooperation, legal obstruction. There's a well-known French lawyer called Vergès who has made that his own, and I see Your Honour is nodding. He didn't. Mr. Abd-Al-Rahman was always more than happy for there to be full cooperation with the prosecution whenever that was reasonably possible. And for that, once again, he deserves recognition. It is, in our submission, necessary for that to be taken into account in mitigation. Again, I'm not suggesting that it should take off years, but it should be taken into account. I now come on to conduct in Riyadh al-Bildi between 2009 and 2019, and the prosecution submissions, and indeed the victims, that this should not be taken into account. We address this in Part E of our written submissions, E Roman 1, E Roman 2, and E Roman 5. Before diving into the substance, Your Honour, two matters. Your Honour addressed with Mr. Lauchi yesterday the standard of proof point, and he generously handed that on to me. So can I briefly address you on a point that's set out in paragraph 58 of our written submissions? I think this is where it was originally found.
It appears an awful lot through your submissions.
Yes.
It's one of the things that is troubling me, I have to say.
Yeah. Well, paragraph 58 is where it
Yeah.
starts off, as it were. But really, this is our point. And I hope I can summarize it briefly and accurately. The Chamber found that the prosecution established beyond reasonable doubt that Mr. Abd-Al-Rahman is and was Ali Kusheb. In so finding, you necessarily had to find not credible those defense witnesses that disavowed the connection. So in other words, their evidence on that point was insufficient to raise a reasonable doubt. Having said that, there were many defense witnesses who spoke of other things. In fact, they all spoke about other things in the course of their testimony. As a matter of law, I think it's uncontroversial to say that a witness can be found to be untruthful about one aspect of their evidence, but credible in relation to others. One example is witness D7, and we address his testimony at paragraph 71 of our sentencing submissions. The trial chamber found that there was that he represented limited reliability and credibility due to his evidence about the Ali Kusheb link. But other evidence did not attract any specific adverse credibility finding against him, and wasn't indeed challenged by the prosecution in their cross-examination. And here I'm talking about how it is that Mr. Abd-Al-Rahman saved the life of a soldier in Songo. So, since matters of mitigation need only be established by the defense to the lower balance of probability standard, we say that defense witness who gave additional evidence to the Ali Kusheb point, who gave evidence, let me put it this way, of a more peripheral nature, evidence that could be categorized as character evidence, can and should be relied on to that extent when there have been no adverse credibility findings specifically to that character evidence. That's the point.
I think I grasped that yesterday, and I see that. The trouble is, and I'll say this now generally as you're dealing with it, that it's not always the case that you're not, on the face of it, seeking to go behind our findings. For example, and let me take which is an aspect that has been referred to by both the prosecution and the representative of the victims, and that is this. It is the empathy that Mr. Lauchi is going to deal with, that it is said that the Abd-Al-Rahman has with victims. But our finding is that he's responsible in one form or another, and sometimes directly, for the death of those victims. So that's what I mean about trying to go behind our findings and saying on the balance of probabilities. But if we weren't satisfied, so that we were sure, convinced, then we couldn't have found him guilty. So it seemed, it is to me an intellectual conundrum, to say the least, as to how you expect us to deal with this.
Yeah. Well, can I make it very clear that for the purposes of a sentencing exercise, we rely on Your Honour's findings. We don't ask Your Honours to go behind those findings. We can't. That would be wrong. But there are circumstances where no specific adverse credibility findings have been made in respect of defence witnesses' evidence. And where that's the case, and given the lower standard of proof, we say it is open to you to accept that evidence in mitigation. And that is all.
I think I do follow clearly now what you're saying. Thank you.
And there's a second preliminary point. As a response to the prosecutions and the LRV submissions about how the defence presented its arguments about Mr. Abd-Al-Rahman as a man of peace, and specifically paragraph 63 of our written statements. And I think a brief explanation is called for here. Paragraph 63, let me put it this way, that may be an instance of over-exuberant drafting. And I understand completely why my learned friends will have picked up on it. The trial chamber did not describe Mr. Abd-Al-Rahman as a man of peace in the judgment, and our endeavour to extrapolate Your Honour's acknowledgement of him playing the role of a mediator may have been clumsy.
You have to. I, again, do not want to go back over the judgment. We've said what we've said in the judgment, but I think you need to look at the context of that one.
Yes.
Where the word, his role as a mediator.
Yes. Well, Ms. von Wistinghausen made the point yesterday, and we accept those submissions to that extent, as it were, nostra culpa. But what we don't accept is a deliberate attempt to mislead or a deliberate attempt to misrepresent the evidence. It really wasn't. It may have been clumsy, but nothing more than that. Having said that, can I move on to the substance? And we say that the prosecution and LRV's positions on Mr. Abd-Al-Rahman's character are not tenable, and they should not be given weight. Irrelevant considerations are focused on by them in an attempt to convince Your Honours not to treat his post-2004 behaviour as mitigation. And for example, they say that the evidence of his, as it were, good behaviour took place in an entirely different location and at a time years after the offending behaviour. And they make no attempt whatsoever to explain why only laudable actions undertaken at the time of the criminal events or at the location of the criminal events as a matter of law should be taken into account by the trial chamber. Once again, I come back to Rule 145.2a Roman 2, the text, which places no limits of place or time on evidence of a convicted person's good conduct after the act. The rule says after the act. So the relevance of a complaint by the prosecution that the evidence of good conduct doesn't relate to the time is completely misplaced. We submit that the where and when factors are far less important than the what and the why factors. What mitigating conduct did Mr. Abd-Al-Rahman engage in, and why did he engage in it? And to the extent that any attempt is made to rely on jurisprudence by the prosecution, the only support for its position is found at footnote 416, the Popovich case before the ICTY. There's no case law from this court cited. Your Honours, you can ignore it. You've seen that there is evidence of D40 and D41 before you, and I'm not going to take you through their statements. We've made false submissions on what they say in our brief. It's right to say that some of the acts do relate to Mr. Abd-Al-Rahman in his capacity as a CRF officer. We accept that. But that is to miss the point. The gravamen of D40 and D41's evidence relates to the efforts made, admittedly after the events, but the efforts made by Mr. Abd-Al-Rahman to bring together people from the various tribes in Riyadh al-Baldi, including the Fur and the Masalit. D40 refers to Mr. Abd-Al-Rahman's speeches calling on the need to live in peace without racism and discrimination, and that these efforts resulted, I accept, in 2014, not in 2003 or 4, but in 2014, he was awarded a medal as thanks for all he did for the benefit of the whole community. D41, he's not of the Taisha tribe, and I say nothing more than that, describes Mr. Abd-Al-Rahman's speeches in which he talks about the brotherhood between tribes, that all are equal before the law, that disputes should not result in violence, that there should be peace. Your Honours, that is entirely consistent with the essence of what Mr. Abd-Al-Rahman exhorts to his audience in the Amsuri and the teacher's video. So when it's suggested that D40 and D41's evidence is in, starkly contrasts with the violent and inflammatory language in the Umsuri and teachers' videos, I'm afraid that's simply wrong, and it's not fair when you look dispassionately at the context of those speeches.
I think, however, both the prosecution and the CLRV were referring not just to the Umsuri video, but all the newspaper reports and the like that were shown to defence witnesses in roughly the period, I think it was 2013 or thereabouts, in which he is still making allegedly inflammatory remarks, is helping to expel the Salamat, and being accused of being responsible for I'm summarising like mad at the moment.
Yes.
But of being solely responsible as head of the CRF in Riyadh al-Baldi for the violence, and indeed expelling, as I say, the Salamat by violence.
Yes. Well, I don't. Again, you've made findings in the judgment, and we can't go behind those findings. All I ask Your Honours to do, all we ask Your Honours to do, is to look at the essence of what Mr. Abd-Al-Rahman says in those speeches, because they amount to strong evidence of exhortations for the different tribes to live together without racism, without discrimination. The Amsuri speech, this is at DAR OTP 000124474. He starts off by saying, first of all, dear brothers, there are no Zaids or Abids, only sons of Junaid. He says, there should be no tribalism, regionalism, or racism. All of us are so tightly bonded that you need a sword to divide us. He's talking here about the community of his town, that we heard from lots of witnesses was a cosmopolitan town. He says a bit later on, all people stand united, all people, brown, black, and Your Honours can be sure that what he means by that is Arab tribes and, as it were, African tribes. All people are so tightly bonded to one another that you need a sword to divide us. That is a message of non-discrimination, of non-racism. And that is what we ask you to focus on. It certainly nuances the evidence that the prosecution rely on. The prosecution also suggests that the evidence of D41 seems to contradict the experience of D29 and D28. And again, I want to stay in open session, so I don't want to go into too much detail. But we say that the two sets of assertions are not necessarily inconsistent. D28 and D29 speak of, or told the defense about the actions of certain elders of a certain community. D41, on the other hand, speaks of the position of the community more broadly, not simply the leadership. So it's not necessarily inconsistent. And yesterday the prosecution suggested at page 33 of the uncorrected test transcript that they're not credible and that had they been subjected to cross-examination, they would have been significantly damaged. Now, we on this side of the bar will always be the first in line to acknowledge the advocacy skills of Mr. Nichols and his team, but he cannot assert as a matter of fact, rather than a matter of aspiration, that D40 and D41's evidence would have been undermined. It is pure speculation, we say, and we ask you to attach no weight to it. Coming back to Mr. Abd-Al-Rahman's character, in our written submissions at paragraphs 58 to 62, we provide evidence of his generous tendencies as a pharmacist, the fact he gave medicine for free to those who couldn't afford it. Again, his role in maintaining intertribal cohesion, and we say that that is supported in the videos.
Because Miss Hornfistinghausen picked on that business of the she says it's an aggravating feature.
Yes.
Because you as a medical man, supposedly helping the community, are in fact wreaking, so she submits, destruction.
Yes.
What do you say to that?
Well, to that extent, we will agree to disagree. We say that he is a man who, in the past, as a man of medicine, has helped the community significantly. And we say that it is not an aggravating feature. Just to summarize, we say that there is a different side to Mr. Abd-Al-Rahman's character than the one portrayed by the prosecution, than the one upon which the evidence in this trial shone a light. Because in the context of a trial, the prosecution will only shine the light on one side of a person's character. The evidence shows that there is evidence that Mr. Abd-Al-Rahman urged communal harmony, peaceful resolution of disputes, and Your Honours may think that in so doing, in the context of Riyad al-Bildi, in the past he must have prevented conflict. He may even have prevented violence in the past. And as a matter of fairness, we ask that that be taken into consideration in determining his sentence. I've come to the end to everything that I can say in open session. My very last point is a point that can only be, I'm afraid, addressed in private session, and I suspect I'm going to take, I'm probably going to take us up to 1 o'clock.
Yes, very well. We'll go into private session.